Since 2013, the landscape of family law funding in England and Wales has operated behind a strictly guarded vault. Before that point, legal aid acted as a broad umbrella. It provided accessible public funding to help resolve the majority of everyday family disputes. That framework was dismantled by the Legal Aid, Sentencing, and Punishment of Offenders Act 2012, or LASPO. The legislation triggered an immediate shock to the justice system. The restrictions stripped public funding away from huge swaths of the population almost overnight. As a result, modern family lawyers operate under a dual mandate. You are an advocate for your client, but you are also a strict gatekeeper for the legal aid agency, or LAA. Securing public funding today is no longer a routine administrative task. It requires navigating a strict procedural algorithm. Every case begins with the client at the top of a decision tree, where dispute facts dictate accessible funding. Traversing this determines your firm's authority, whether you act autonomously or must formally petition the LAA for permission. Understanding this framework is a requirement for any firm attempting to balance the needs of the client against the rigid oversight of the LAA. The first hurdle in this algorithm is the scope gate. This rigid binary assessment separates cases into in-scope or out-of-scope. The in-scope pathway is narrow. Public child law and protective injunctions automatically qualify to move forward. However, most standard private child, divorce, and financial applications fall into out-of-scope. To force an out-of-scope case through the gate, you have to prove an exception. The client must provide specific, rigorous evidence of domestic abuse or risk of child abuse. The acceptable proofs are strictly defined in the procedure regulations. This means securing police arrest records, existing protective injunctions, or certified health professional reports. There is also an emergency funding exception. If an applicant or child is in imminent danger of significant harm, firms with the right credentials have devolved powers to grant legal aid immediately. Surviving the scope gate only means the case is eligible for public funds. It does not dictate how your firm is allowed to administer that funding. To process legal aid, your firm needs an operational engine. That engine is the Specialist Quality Mark, or SQM. Once in scope, the flowchart splits into two columns: controlled work and licensed work. Controlled work covers early-stage assistance like legal help. The advantage is autonomy. With an SQM, your firm has devolved powers to assess merits and sign clients internally without waiting for external approval. Controlled work covers advice and drafting, but cannot issue formal court proceedings. For litigation, you move to the parallel track, licensed work. This introduces bureaucratic friction. Your firm loses autonomous power and must formally apply to the LAA for a certificate before moving forward. A practitioner's efficiency relies on knowing this boundary. You have to diagnose exactly where your devolved franchise powers end and LAA's central authority begins. Before funding is released, the client faces the final administrative checkpoints, the means and merits tests. This chart shows the rigid financial threshold for the means test. The current capital limit sits at exactly £8,000, and having assets above this line immediately disqualifies the applicant. If they pass the means test, they face the merits test. For family help lower, the LAA asks, would a reasonable person, using their own private money, choose to pursue this matter? Often, the algorithm fails the client. They might lack the specific domestic abuse evidence required, or their assets sit just above the threshold, locking them out of public funding completely. When dealing with a wealthier spouse who controls the family assets, the primary private fallback mechanism is a court order to secure legal costs. This moves the funding battle out of the administrative realm and directly into formal litigation. Under Section 22ZA of the Matrimonial Causes Act 1973, a spouse can apply for a legal services order, or LSO. To win an LSO, you must meet the rigorous criteria established in the case of Rubin v. Rubin. The judge must be fully satisfied the applicant cannot reasonably secure funding through a loan or a charge on a property, compelling the wealthier spouse to cover the fees. Whether the money is extracted from the public purse or ordered from a private opponent, the financial architecture of the case must be mathematically secured before any substantive legal strategy can begin. Even after securing legal aid, clients often hold a dangerous misconception about what that funding actually is. The funding creates a binding financial liability. Legal aid is not a government gift. It is a strictly tracked loan. If the LAA cannot recover the costs of the case from the opposing party, they utilize their ultimate non-negotiable cost recovery mechanism, the statutory charge. This charge is triggered whenever a client gains or retains property or money as a direct result of the legal dispute. The LAA claws back the public money they fronted. They will apply to the land registry and place a legal charge directly onto the title deed of the client's property. The scope of this clawback is aggressive. In the case of Morgan v. Legal Aid Board, the couple tried to evade the charge by giving the wife the holiday home in their settlement. The court simply applied the statutory charge to the holiday home instead. The responsibility for advising the client about this charge falls entirely on the legal practitioner. Failing to explain the statutory charge or mismanaging your SQM franchise files triggers an immediate LAA audit. A failed LAA audit carries devastating consequences. The agency can refuse to pay your firm's fees for the work completed, or they can entirely revoke your specialist quality mark. Mastery of the LASPO algorithm serves as a firm's primary defense against the financial